I'm still standing. I promise
You
not
are.
for long, but could the court indulge me for 5 minutes to make 3 points?
Yes.
So the first is that the court has been handed a questionnaire.
Yes.
Which I've seen before. It was in the bundle before the first tier tribunal.
Yes.
And it's the questionnaire that formed part of the legacy programme consideration. The point is to be made against me, as I understand it, that it doesn't ask for anything about good character. I accept that. However, on the front, a false nationality is asserted, and it is a relevant part of the consideration, as I've shown the court yesterday, that good character is taken into account. So if an applicant continues their deception, the Secretary of State is deprived of the opportunity to consider that issue. See Matusha. So that's all I have to say about that questionnaire. The second and the third point relate to Begum. First, I've taken the opportunity to read again Piazzada, and it's right that I just draw the court's attention, if I may, to some passages in Piazzada first, and I don't think...
Sorry,
it's
where is it?
It's in tab 16.
16, thank you. Yes.
So the first point is that it's paragraph 9E, which is quoted in Begum. The second point...
9E.
9E at the top of 503. So it's not the whole of it, it's the bit that...
There is no suggestion
that's where that comes from. The second point is that there was a human rights claim as well in this case, which now would also permit oral evidence to be given in relation to relevant issues. The third point, in relation to paragraph 13, which quotes from the first tier's judgment,
yes,
the material that the first tier is looking at there is, as I read it, material that would have been before the Secretary of State at the time of the decision.
yes.
And then finally, just to match up to the bit that the Supreme Court focuses on, if one looks at the language of Mr. Ockleton in paragraph 16, it's very much the language of public law review, because he talks about in paragraph 16, Judge Hopkins was right to see whether the Secretary of State was entitled to conclude. And then further down at the end, the court makes the point that the decision letter failed to demonstrate any basis upon which the Secretary of State could properly say that Section 43 applied to the claimant, and that's mainly because the Secretary of State mucked up getting the power right and not being clear about whether this was a Section 42 or 3 case. So we say when one looks at Piazzada as a whole, it supports the passage that the Supreme Court refers to. But I just wanted to reference those passages, and then...
Well, some of that may be explicable on the basis that the FTT allowed the appeal on the grounds that the decision wasn't in accordance with law.
Yes. But it's that language of right in looking to see whether the Secretary of State was entitled to conclude fits with the principle that Mr. Ockleton sets out.
But in the context of a decision by the FTT to allow an appeal on the grounds, I mean...
Yes.
And that's why sometimes one can have very sophisticated arguments on both sides about this that actually makes very little difference in many cases.
Yes, and as I say, I mean, for us, it's the reference to the bit of paragraph 9E in the judgment in Begum. And then finally, just to assist in relation to the question of what is an issue on this appeal, I've already submitted that if the appeal is dismissed, the Begum issue doesn't arise. Could I just make a discrete point which ties into some issues which were debated yesterday, and it's this, that there are obviously discrete issues in these cases. In some cases, there may be an issue as to whether there has been a fraud at all. There's a secondary issue or a second issue as to whether, if there was a fraud, it was material, or in other words, was the citizenship obtained by means of fraud? And then third is the discretion question.
Yeah.
Now, Mr. Southey and I, in our submissions, are at either end of the scale. I say Begum covers all of those questions.
Yeah.
He says it covers none of them.
Yeah.
Now, my primary submission is that it covers all of them, but insofar as what I've called the was there a fraud issue, that's not an issue in this case because it's common ground that there was a fraud. The issue in this case is was the fraud material in the acquisition of citizenship, and I say absolutely on the authority of Begum that is a question which the tribunal can only decide by reference to public law principles. So even if this court were against me on the first point, it doesn't arise in this case, because in any event, we submit that on the authority of Begum, it must be right that given that that's an assessment, given that it's an area in which the Secretary of State is particularly expert, was the citizenship obtained by means of fraud, that falls to be assessed by reference to public law principles.
But I mean, the argument the other way is it's a straightforward factual inquiry. Was there a fraud? And if so, looking at the application form, looking at the decision and so on and so forth, was the citizenship obtained by means of that fraud?
Yes, although we say that when one looks at the decision letter in this case, which is considering that second question, it's clear that the Secretary of State is doing an assessment by reference to her own policy.
Oh, sure, that's for the Secretary of State, but that doesn't answer the question necessarily whether it's capable of being a straightforward factual inquiry on an appeal.
Yes, well then, in this case, we say, this case illustrates that that materiality question is a question which ought only to be subject to public law review.
Right.
And a fortiori, to the extent that an issue arises about discretion, we say, absolutely, Begum makes clear that the tribunal can't exercise the Secretary of State's discretion. So there are, I just wanted to make that clear because at the moment we're at opposite ends of the scale.
Sure. Yes, so there's room for positions in between the two opposites.
Indeed, and certainly those are that's our position on the bits in between. So I hope that's helpful.
Can you just remind me on your position as to the relevance of the Begum issue to this appeal? In other words, it's not directly an issue.
Yes, so we raised it as a respondent's notice point simply because it was another basis on which the upper tribunal could have decided that the first tier had got it wrong. However, in the usual way, if the appeal is dismissed, then the appeal is dismissed. There's no need for my respondent's notice point. The upper tribunal has directed that the matter is to be considered in line with Begum, and that's what will happen unless we end up back in this court in this or another case. So there isn't a need. It will be obiter in my submission, and if there are degrees of obiter in terms of breaking it down between those 3 points, this is a case where it's common ground that there's been a fraud, so no factual issue arises in relation to that question.
And one of the problems with obiter observations is their impact, because as they're obiter, they may not be subject to an appeal. They're not binding. So what would your submission be as to our judgments dealing with that issue?
Could I turn my back for a
Yes.
moment? I'm very grateful. Yes, we're neutral. If we're neutral in effect, all I can say is that it doesn't directly arise, and it will be obiter. But we are neutral, and I think I also fairly have to accept that it will be coming back to this court at some point, if not decided in this case.
Yes.
But it's that certainly we accept that it doesn't directly arise if the appeal is if ground 1 is dismissed. We certainly would have felt bound to draw the court's attention to Begum, even if we hadn't advanced it as another reason why the first tier got things wrong. But if ground 1 is dismissed or allowed, it doesn't need to be decided. That really is. I'm very grateful for the indulgence.
No, not at all. Yes.
Thank you, my lord, my lady.
My lords and my lady, if I can, responding to my learned friend. My learned friend started by making some...
Sorry, just while it's in our minds,
Yes.
do you mind addressing the point that we've just asked about the appropriateness of this court dealing with the Begum issue?
We strongly urge the court to deal with the Begum issue, as I think I made clear yesterday.
Yes. It would be over to.
Well, not necessarily in the sense that because there is effectively the respondent's notice, it would be open to this court to, it depends on which order the court deals with matters, because one of, if you like, the most fundamental challenge to the approach of the first tier tribunal judge is one raised by the respondent's notice, in the sense that if Begum applies, and if Begum applies, then much more fundamentally than the approach to Sleeman, the sorts of arguments we've adopted, clearly the first tier tribunal judge gets it wrong, in the sense that the first tier tribunal judge doesn't apply Begum. And so, in one sense, that's the reason we dealt with it in our skeleton argument in the way we did, because if my learned friend is correct in her respondent's notice, that's a bit of a knockout blow, basically. We would have to be remitted on the basis that the case needs to be considered applying Begum. So I'm not sure I necessarily accept, depending on how the court resolves. I mean, that's why we're talking about the issue of the order, because equally the court, it would be open to the court to say, well, actually, the upper tribunal was entitled to reach the conclusions it did.
Okay, let me put it another way. If what we said was overturned, it might, what would you then say? Because it creates problems, doesn't it, in terms of its impact, the prospects of appeal.
Well, the second and third points I'd make in any event, which is one of the reasons why I would urge the court to deal with it potentially the way I described, which would mean that the judgment wasn't overturned, is that you've heard extensive submissions. There are a line now of upper tribunal authorities which, if my submissions are correct, are wrong. The decision of the upper tribunal was essentially to remit, consistent with those authorities, requiring the application of Begum, which we would say is wrong. So what you've got is this particular appellant, as things stand, being bound by the approach of the upper tribunal to Begum, which we would say is wrong, and presumably significant numbers of other appellants also being bound by that. And having heard the extensive argument in our submission, if that is wrong, it's quite important to bring it to an end.
I see that, but I can also see the criticism being made of an important issue of that sort being determined over to.
Well, that's why, in one sense, I was saying you don't necessarily...
I understand that.
necessarily need to do that. But even if it is determined arbiter in my submission, it is still, because if fundamental rights are, appeal rights are of such fundamental importance, if the reality is that appeals at the moment are being determined on the wrong basis, and the court, and this court's obviously heard argument about that, so it's in a position to reach a conclusion about that, then we would certainly submit it's important that that's brought to an end as soon as possible.
Because the formal order made by the upper tribunal at page 38 of the bundle just remits it to be heard at Birmingham. It doesn't say anything about that. I mean, if there had been an order saying in accordance with Begum principle or in accordance with Shyti principles, then there would have been something that, if you were right on this and we were still minded to remit, we would be able to make an order saying, but on these bases, which would give the Secretary of State something to appeal against if she was so minded.
Well, except if you were to determine the appeal on the narrow basis without determining as sort of the first stage the Secretary of State's respondent's notice, it would, I suppose, still be open to the court to deliver a judgment saying, essentially, we agree with the terms of the upper tribunal's judgment that at para 17 that remittal should take place following the applying the principles in Begum. That could be reflected in the terms of the order, and that would still give the Secretary of State something to appeal. I mean, as I think my Lord has just put to me, if the upper tribunal order had been phrased differently, which it could have been, one would be potentially in a different position. So, again, in terms of protecting the appeal rights of the Secretary of State, the order, I'm sure the order could be crafted in a way that ensured that.
Okay, thank you. Yes.
Turning then to the substance of the appeal. My learned friend started by making some submissions about the context of what is in issue in this case and making the point, which is obviously not controversial, that applications for citizenship needed to be established, applicants for citizenship rather need to establish good character. And she referenced a series of principles set out at paragraph 26 of her skeleton argument. Those principles are not in dispute, but what they make clear is that what amounts to good and bad character is a matter for the Secretary of State, essentially. And that's why policy that applied at the time is so important, because that represents essentially the judgments of the Secretary of State. And one of the dangers, and one of the reasons why I wanted to start with this, in the approach that underlay the submissions of my learned friend yesterday, is that at times in my submission she came close to inviting the court essentially to determine that citizenship would have been refused, or it should conclude rather citizenship should be refused in light of falsehood. Effectively, she was asking the court to make its own judgment as to what should have happened when the citizenship application was determined. In our submission, if one looks at the language in particular of section 40, which requires consideration of whether or not the citizenship was obtained, if I remember the language correctly, yes, it's obtained by deception. The issue for any court is what the Secretary of State would have done at the material time. So the question is, and my learned friend said this morning that the issue wasn't a counterfactual world, that was her language, and whether the applicant would have, how the applicant would have fared in a counterfactual world. That's wrong in my submission, because if the question is whether citizenship was obtained by deception, the exercise that has to be performed in my submission by the court is to consider what the reaction of the Secretary of State would have been had the Secretary of State been aware of the deception. And the way a court assesses that is by looking at the policies that were applied at the material time, looking at the evidence as to what factors were taken into account at the time of the decision, and reaching findings of fact. And of course, those sorts of findings of facts are one that courts have to make often. If one thinks about the criminal justice system at times requires consideration of whether something was obtained by deception. That requires consideration of the extent to which something was material, or deception was material. Courts are used to doing that. It doesn't involve looking at historical evidence, but that is something courts are well equipped to do. And that, ultimately, one of the reasons for making that point is that in our submission, if the matter is to be remitted, obviously our primary position is that the upper tribunal erred, and so the matter shouldn't be remitted. But if the matter is to be remitted, in our submission, this court should be cautious, essentially, about avoiding stepping into the role of the first-tier tribunal. And the role of the first-tier tribunal will be, as I've described, which is to decide essentially whether, on the evidence it has before it, the admitted deception was material. The other part of the context that my learned friend referred to was the fact that Parliament had enacted legislation that enabled someone to be made stateless if deception is material. That, in our submission, is in fact, in one sense, a point that supports our arguments. The fact that Parliament has decided to enact a provision which is potentially draconian, as it potentially leaves someone as stateless, demonstrates in our submission why, equally, Parliament identified the need for there to be causation between the deception and the obtaining of citizenship. That causation is an important way in which Parliament restricted the exercise of this power. This is where there really was, in one sense, an unfairness to the state, because the state had granted someone something which they wouldn't otherwise have obtained. Turning then to the facts, my learned friend started with the ILR decision and placed substantial weight on Matusha, an authority that I said I'd respond to if necessary. Matusha, firstly, it's worth noting, noted, and Matusha's at tab 23, noted the sort of historic case law regarding the legacy of Hakimi and Giraldo, and I'll just make a couple of points about those later. One of the things, though, that I would highlight in it is that the legacy programme, as is clear from the citation of Giraldo at para 11 of Matusha, in general, was focused on failed asylum claims. You see that from the third and fourth line of paragraph 39. That's important. It's a point made in Schliemann. I won't give you the reference, para 63, because it means that the legacy programme will have included, by definition, a significant number of people who presumably had made claims that were false. Obviously, some asylum claims are refused on the basis that they're false. That didn't prevent necessarily people getting legacy grants of legacy leave. When you come to the contemporaneous decision-making in this case, the underlying reason why the asylum claim was refused doesn't appear to have featured as a significant factor. The rules that my learned friend then took you to at para 19 and the policy at paragraph 22 says that account will be taken of deception, doesn't say how it was needed to be taken into account. What then followed was paragraph 26, where the upper tribunal talks about the nature of fraudulent representations. But what they're saying there is their own views, essentially. They're setting out their own views about the significance of fraudulent representations. What they're not doing there is referencing the approach the Secretary of State would have taken at the material time when ILR was being considered. The fundamental point, which makes it very difficult in one sense to draw very much from Matusha, is that Matusha was ultimately a judicial review. That means that if one looks at the key reasoning, paragraph 57 and 60, for example, you see that the question that was being asked, see the last line of sentence of paragraph 57, and the second sentence of paragraph 60, was whether the Secretary of State could have taken account of past deceptions. That was taken into account because if you look at the third sentence in paragraph 60, which effectively is the last 5 lines on page 671, the issue that was being asked was whether the Secretary of State's decision was within the range of reasonable responses. Here, if we're right about Begum, and if we're right in particular that what the tribunal needs to do in this sort of case is decide whether the deception was material, the issue isn't whether the Secretary of State could take account. The issue is what would have happened had the had the true facts been known. And that's an issue, ultimately, if it's on remittal, we submit, it is one for the, as I say, for the first tier tribunal. That's where our arguments about Begum come into play. And what we submit would need to be considered is the material about the legacy, which proves part of the context. And just to give you some flavour of that, if you look at Giraldo, which is in the authorities bundle at tab 6, paragraph 54, the legacy was described by the Secretary of State's witness. Mr. Forshaw was a witness for the Secretary of State, as meaning all things being equal, one got leave after 6 years, demonstrating the significance of length of residence. Hakimi, which we handed up, gives a little more colour to that, at paragraph 8, and in particular, Hakimi makes the point that there was a distinction drawn between effectively what was described as non-compliant immigration behaviour and criminality. Generally, non-compliant immigration behaviour didn't prevent a grant under the legacy. That's, in our submission, consistent with you've seen, I won't take you back to them, the approach that's adopted to character in the notes. You remember the GSID notes, which are at supplementary bundle, page 44. If you look at the character factors that are considered in that context, the Secretary of State's asking themselves essentially whether this is someone who's committed a war crime. That's the sort of nature of the character factors that are being considered. The form, my submissions have been anticipated in relation to the form. The form does record nationality, but that seems to be basically to enable the individual to be identified. It doesn't really ask questions about character, and the decision itself talks about The decision itself talks about length of residence. And that's, in our submission, they're the sorts of things that, if this is remitted, ultimately the first-tier tribunal will need to look at to reach findings of fact. It will do that in light of things such as the good character guidance. And we do submit that example B is relevant, because what example B shows in our submission is that the approach of the Secretary of State is to focus on the reasons why someone was granted asylum, or rather why someone was granted leave, more accurately, rather than what the what the Secretary of State wasn't told. And that goes back to the point I made before about causation. And true it is, it refers to the family policy. That's why we handed up AW. But AW made the point that the policy was set out essentially at paragraph 3. And that included, unsurprisingly, a provision that prevented someone getting leave under the family policy if that was not conducive to the public good. So there was always a character consideration in relation to that.
Sorry, Mr. Southey.
Sorry, I'm going quick.
No, which paragraph? I didn't.
Paragraph 3 is very long, in fact, and it's probably easier actually to go to paragraph 4 and look at the line about the bullet point above. That's the last of the exclusions from the family policy.
There's a criminal conviction for a recordable offence.
No, the last bullet point is a general presence not conducive.
Oh, I see. Presence not conducive to the public good.
Yeah. And
Is that the same as somebody being a bad character?
Well,
is it?
Well, it's potentially wider than bad character, but it would. It's a bit, I mean, it seems slightly unlikely that the Secretary of State would say you're of bad character, but it's still it's not.
I'm sorry to stand up. I don't think that's right. I think one need only look at some of the cases which have been refused on good character grounds to see that those aren't cases where the Secretary of State would, for example, seek to deport or deprive
on conducive
on
grounds.
conducive grounds.
Yeah.
But the point I'm making is that conducive is context specific.
Yeah.
And it gives the Secretary of State a broad.
Yes, but I think the point that's being made against you by Ms. Smith is that bad character is a broader concept than presence in the UK not being conducive to the public good. They aren't coextensive.
No, but the point I'm making is that if you go back to what was said about the legacy,
yeah.
The legacy never said that bad character automatically led to refusal. It said it was a factor. So it was a factor that could be taken into account.
But the family policy doesn't seem to have an exclusion of the bad character.
It hasn't.
To our attention, it's just presence in the UK not conducive to public good. Criminal conviction.
It has an automatic exclusion. The difference is this, as I see it. It has an automatic exclusion where that is conducive to where the Secretary of State concludes that it's conducive to the public good. You should not be granted family leave. That's automatic. That could include character issues. This we would submit. But ultimately, the question is conduciveness.
Yeah.
With the legacy programme, character was a matter that was to be taken into account, but it wasn't determined. It wasn't an automatic exclusion.
Yeah.
The legacy process overall indicates that, and this is the passages I took you to, that very significant weight was given to length of residence. Non-compliance with immigration control was not necessarily a bar in cases of long residence, but criminality generally was a bar.
Just to be clear, are you suggesting that non-compliance is the same as telling lies in an immigration application?
Well, it's a form, perhaps a serious form, but it is a form of non-compliance in the sense that the all I'm saying, what the fundamental point I'm making in one sense is that the distinction that my learned friend tried to draw between this case and the family policy is not as clear as we would submit. She submits it is.
Right.
On a fact-finding exercise at the FTT level, what the Secretary of State has, what the first-tier tribunal judge has to do, is consider whether or not citizenship was obtained by deception, using the language of the statute, if I remember it rightly.
Yeah.
That turns on the Secretary of State's view of material, including the policy on good character.
Sorry, is your submission that it turns on the Secretary of State's view?
No, it turns on the immigration judges, first-tier tribunal judges' view.
That's why
Yeah, sorry. If I said the Secretary of State's
you
view,
did.
sorry, then that was a mistake.
Just wanted to be
No, absolutely. That was a fairly fundamental mistake.
Your case in reply.
Yes, I know. I wasn't making a sudden off-the-hoof concession, but sorry. It turns on the first-tier tribunal judge's view of the policy and the contemporaneous documentation, because that's the material that demonstrates the approach at the time.
Yeah. Okay.
And this material forms part of that. Turning then to the...
So your basic point is, on a remission, even though fraud is not an issue, you say there are factual issues for the FTT to decide in relation to causation.
Yes.
Yeah.
Okay. Yes. And all I'm really saying is, sort of, perhaps more fundamentally in one sense, Matusha isn't the knockout blow that my learned friend seemed to suggest it was, basically. The issues are complex if you've got findings of fact, not a judicial review. That means, and one needs to remember that the Secretary of State's policy, just to make this clear, and at the very least one gets this from Chapter 19, demonstrates that materiality, the Secretary of State doesn't do what she might do, which is say a falsehood is always a basis for refusing citizenship on character grounds. The Secretary of State's policy is to look at materiality. And remember, Chapter 19 is the pre-citizenship policy. So what Chapter 19 is saying to people who are charged with the decision of granting citizenship is, you may have made I paraphrase this, but I hope accurately, or I summarised the effect of this. You may have made a material false statement, but depending on whether or not that was material to whether or not you got your immigration status, we may or may not take account of that in granting you citizenship. And that's the key point in one sense, but about example.
Just remind me, first of all, which tab this is, and also which paragraph. You don't need to turn it up. Just remind me.
Yes, certainly. It's chapter. When I said Chapter 19, it is the. Sorry, it was Chapter 18, tab 47.
Tab 47.
And the paragraph. Well, it's paragraph 9.5, and then the examples.
And the examples, yeah.
Yeah,
okay.
it's example A contrasted with example B.
Yeah. Thank you.
And that's and obviously that policy in one sense is clearly relevant because the Secretary of State accepts it's relevant in her decision in this case. Her decision to deprive refers to that in policy, and it's clearly relevant. So that's the context in one sense in which one should consider the submissions of the Secretary of State as to institutional competence. If I'm right about describing the exercise that needs to be conducted, the issue is one of historic fact. It is what was the basis of the original grant of citizenship, and would the falsehood have made any difference in relation to that? That is, in my submission, something that courts are, as I've already indicated, well equipped to assess. Courts will have the assistance of the material, the evidence that I've identified. And assessing a historic fact is something that the Secretary of State has no greater institutional competence in our submission. Because what the Secretary of State is looking at is trying to, when the Secretary of State looks at this issue, is looking at what was in the mind of a decision maker potentially many years ago.
Yeah.
Turning then to the grounds of appeal, we don't dispute that ultimately the question has to be whether the FTT approached the issue in the correct way. Having said that, clearly what was in issue depends in part on how the Secretary of State framed their case, which is why in our submission the FTT was entitled to reach the conclusions it was. That's the context in which the focus was on the grant of ILR. In our submission, that appears to have been what the first-tier tribunal judge understood to be an issue, given effectively what he'd read and the conclusions he'd reached about the decision letter and the submissions of the parties. And that's where he was asking for assistance and didn't get it. That in our submission, at the risk of repeating myself, that in our submission is a legitimate approach. My learned friend points to the upper tribunal grounds, and the grounds were wider. Obviously, the starting point, though, in one sense, is the basis upon which the UT allowed the appeal, and that is the point we sought to identify from the grounds. Obviously, the respondent's notice goes further than that, and both parties have addressed the respondent's notice, but fundamentally, the approach of the UT was to allow the appeal on a relatively narrow ground. Sleeman.
Well, it's a concisely expressed ground.
Yes. Sleeman, my learned friend, says was effectively wrongly applied. It wasn't binding. In our submission, the point about Sleeman is that there's no suggestion it was wrongly decided on its facts. The question in our submission that the tribunal judge was then entitled to ask was, could it be distinguished? And that was the question he was properly asking himself. That the differences factually between this case and Sleeman in our submission are not material, and in particular the point that was made about the awareness of the full state. My learned friend argued there was material in Sleeman that indicated that by the time the Secretary of State granted ILR in that case, the Secretary of State was aware of a false date of birth having been claimed. But in one sense, that supports the appellant's arguments because it demonstrates how the Secretary of State wasn't necessarily refusing ILR where a false statement had been made. Turning then to Begum, my learned friend started with the statute. In relation to that, I'm not sure there's many points I need to make. All I would say is that, of course, it's correct that SIAC does essentially deal with the same appeal issues as the first-tier tribunal. The point I was making about the specific issues that arise in relation to SIAC is that in reality, SIAC is likely to be considering issues of national security. That's the basis on which material is generally withheld. I think it's the basis on which material, it's not technically the basis on which material needs to be withheld, but it's generally the basis on which material. And that national security concern clearly underlay the approach of the court in Begum, and explains as well why SIAC appeals go to the specialist body rather than the body that normally is the venue for appeals, the FTT, which is normally able to consider issues of discretion.
So there are two, as it were, two levels of discretion involved in a SIAC appeal like Begum. Firstly, the fact that the ground of deprivation is conducive to the public good, and secondly, that it's national security.
Yes. The second sort of point about the statutory framework is, and again, I think I made this clear in opening, but there is no dispute between the parties that Section 86 was never incorporated into the British Nationality Act, into appeals under Section 40. One reason for that in our submission may be that Section 86, as you saw in my learned friend submissions, ultimately, in one sense, restricts grounds of appeal, because what it does is it says you can conclude a decision is not in accordance with the law, or discretion should have been exercised differently. But if you don't find either of those things, you should refuse the appeal, effectively. So it's both a provision that sort of grants grounds of appeal, but also narrows them in one sense. What in our submission was, as I say, key was the choice of Parliament to enable an appeal to the first-tier tribunal. And the nature of, in circumstances where Parliament was clearly aware of the nature of the work undertaken by the first-tier tribunal. Committee rules, we'll put in a note in relation to those. What is perhaps important is not just that they enabled evidence to be called, they also enabled at the committee to require an explanation for the Secretary of State for a decision, implying essentially that what the committee was looking at was, in light of evidence, whether that explanation was a good one. Of course, it forms part of the context because clearly the Secretary of State, because clearly Parliament was seeking to expand the rights of individuals by providing an appeal. Pirzada in our submission, I'm not going to spend any real time on it. In my submission, it doesn't really help because ultimately, on a fair reading of Begum, Lord Reid notes it as part of the history, effectively, of the case law, in circumstances where he's not dealing with the issue that arises in this case. He doesn't go beyond noting it as part of the history of the development of the case law because he's not dealing with the specific issue that arises in this case.
Yeah.
And that's also the context of my learned friend's reference to the paragraph 46 onward of Begum, which we'll remember is where Lord Reid reviews the various appeals cases, generally tax cases. He focuses on paragraph 46 on the approach taken in appeals on statutory discretion cases. Obviously, our case is this isn't a discretion case. What those cases make clear in our submission is that even in that context, one needs to look at the nature of the decision. And those decisions were appeals in relation to matters where there was a heavy policy aspect to the appeal, or the subject matter of the appeal. Here, the policy is as set by the Secretary of State essentially in advance of decisions. It's what is good character, what is bad character. what is going to be taken into account when a decision is made on citizenship. Whether in light of that policy something was material, that is ultimately an objective question. It's a question to be decided on evidence. My learned friend's basic problem in our submission is that her submissions ultimately focus on the language of satisfied. That's really what her case turns on. But Bacon's plainly more complex than that, because Lord Reid wouldn't, if it all turned on the language of satisfied, needed to have considered it Raymond, all the material about national security. It would be inconsistent with the approach to statelessness. And my learned friend's argument about statelessness being sui generis in our submission simply doesn't work. Firstly, she says statelessness is a question that will actually turn on the state of matters at the date of decision. Well, so will fraud and materiality, because if fraud and materiality is being relied upon, it's being relied upon because there's already been a fraud that was material. Secondly, she says the approach to statelessness is derived from international protection. That's where, in one sense, the judgment my lady referred to yesterday of Lord Justice Lewis in E3 is relevant, because that makes the point that procedure isn't an international obligation. The obligation to prevent someone being made stateless is an international obligation. How you assess that is not an international obligation. Finally, she argued, albeit retreating a bit from this, that statelessness was a question of law. It's plainly a question of fact. If there were to be a judicial review of, and it's difficult to see how this would arise in practice, but if there were to be a judicial review of a decision of the Secretary of State as to whether someone was stateless, unless this was a condition precedent case, the sort of Quadja case, it's clear in our submission, because it's no different to any other issue of fact, the question would be, was the Secretary of State reasonably entitled to reach conclusions that they reached regarding statelessness? There would be no basis for unless the statute was in issue was in odd terms that meant there was a condition precedent. The basic rule would be it's a finding of fact. It's no different to any other finding of fact. On judicial review, it can only be challenged on Wednesbury grounds. In our submission, the key point that one gets from the approach to statelessness, which is entirely consistent with everything Lord Reid says in Begum, and in particular what he says about appeal provisions generally, is that context is key. Discretion is one thing. Objective facts are quite often a different thing. And the problem with my learned friend submissions is that they effectively convert the appeal into a judicial review. And that's precisely what Lord Reid starts by saying, by implying is wrong, because Lord Reid starts by emphasising the distinction between an appeal and a review. My learned friend's final submission this afternoon essentially sought to distinguish between fraud and materiality. But in my submission, there is no distinction. They are both historic facts. Either the fraud had an impact on a historic decision or it didn't. And all of that demonstrates in our submission more fundamentally that there is no reason, no basis for this court departing from KV. KV in our submission remains good law. And it's not correct in our submission to simply say that was a Lord Legate recording what the parties had agreed. What Lord Legate actually said at paragraph 6 was that he was endorsing the principles of the upper tribunal, and in part he needed to do that because he went on to resolve for himself whether KV was stateless. So he needed to consider the approach to fact-finding. If you look at paragraph 54, I won't take you to it, it's tab 19. Lord Legate, in circumstances where the Secretary of State was arguing to the contrary, he resolves for himself whether or not KV was stateless.
Seems an unorthodox thing to do on an appeal.
Well,
On the point of law.
Well, except the reason for it, I think, was that ultimately the courts below had wrongly failed to address that issue, and so it was potentially material to remission.
Would you accept that, I think it's the fourth subparagraph of paragraph 6 of KV might need to be revisited in the light of Begum? I think it's the paragraph that deals with the exercise of discretion.
I think, just looking at that.
I've got that right. Yeah, so paragraph 6(4), if condition precedent is established, the tribunal then has to ask whether the Secretary of State's discretion should be exercised differently.
What I would accept, in KV, that needed to be read with sub 6. So it wasn't what Lord Justice Legate, rather, as he then was saying, was not simply effectively that the first-tier tribunal retakes the decision. He was saying that great weight effectively needs to be given to the...
Yes, but he repeats it in 6(5), Article 6(5), even if Article not engaged, tribunal will still consider whether the discretion should be exercised differently. And then he says you defer to the Secretary of State's view about that, because Lord Reid seems to be saying in Begum the discretionary decision is for the Secretary of State alone.
Well, Lord Reid is saying discretion is for the Secretary of State alone. He is saying that you apply public law principles. Public law principles, obviously, in a non-national security case at least, would potentially allow for a conclusion that the decision of the Secretary of State is outside the range of reasonable responses. I'm not sure there's a huge difference between saying, effectively, is the question, was the decision outside the range of reasonable responses, and giving great weight to the analysis of the Secretary of State.
Right. Okay.
Recognising as well that Lord Reid in FAM recognised that intensity of review, Lord Reid rather endorsed Lord Sumption's remark in FAM that intensity review depends on context. And so if you've not got a national security context, there may be a slightly more intense review by implication.
All right.
So, but also to be clear, our position is, because my learned friend I think in submission suggested it might have been, our position is certainly not that you go beyond KV and conclude that in relation to discretion in this context, the first-tier tribunal simply retakes the decision. Our position is KV remains good law in non-national security cases until reviewed, effectively. A few other sort of things, very briefly. Precedent fact case law in our submission simply doesn't assist. It's dealing with judicial review, and it's only relevant if my learned friend is correct, essentially to say that judicial review principles apply. The only point we would make, though, in addition about Geary, is that in Geary, paragraph 20, tab 13, ultimately the court seemed to accept that where there was an appeal, there would be fact-finding. And that's why the issue, in one sense, in relation to Section 10 cases, I think there were, was said to be irrelevant.
Sorry, what was that last reference you gave?
It's Geary, paragraph 20, the last sentence.
Thank you, that's fine.
Finally, in terms of the UT authorities, my learned friend referred to mucilage. I should say in passing, because my learned friend suggested it was factually similar, it is clearly not factually similar because it is an example A case. It's someone who got refugee status by making false representations. In any event, our basic point about the upper tribunal decisions is we accept that they are inconsistent with the point we are making about Begum. Our submission is they misunderstand Begum, and obviously they don't bind in any way. And that goes in one sense to the reason why in our submission it is important for this court to take the advantage of, take this opportunity to correct that, because there is now a long line of authorities that we say are wrongly decided.
Thank you.
Thank you, my lord.
No?
Thank you.
Thank you. Well, thank you all very much for your submissions. We are going to reserve our judgments. They will be provided to you in draft in the usual way for typographical corrections only, and you know the harsh penalty potentially applicable if they're used for any other purpose. And we would hope that once you've received them, you'll be able to agree a draft order. But if not, we will deal with any outstanding matters on paper. Looks about to say something else, but no.
No.
Another mystery response.
Oh, tomorrow is not before 10:45.
I'm very grateful. You will.
Yes.
Thanks to both of you.
Thank you.
For being lovely opponents. And to you.
No, thank you. That was lovely.
And I hope your trip goes well. You. And we'll be in touch. We're going to start a draft off, so we'll be in touch with you about that.
Brilliant. Thank you. Thank you. Well, can't really wish you well tomorrow, but
Wish me well
I hope
staying up for the rest of the day.
yeah. I hope from a personal point